as you heard in part one, there were just numerous things that were occurring. So ultimately, I filed for injunctive relief with the Northern District Court of Ohio. In that memorandum of opinion and order, it stated that the federal interference in state criminal proceedings is disfavored, and only exception to the rule against such is when irreparable injury, both great and immediate, to federally protected rights will otherwise occur. Younger versus Harrison. So on September 14th, I had gone to I think it was the 13th, I had gone to the municipal court to file some petitions within those cases. And in that period, I had asked to review the cases, OMVI, the ALS, and the driving under suspension. While I was there, I was examining the folder, and I had seen some scribble marks and things. I realized that this document, which is done under falsification and perjury, is not the carbon copy that I had received. And then I realized it appears that the judge had known these issues. So here's a copy. Here's defendant's copy. You see non-injury. So I attempted to file or get copies of things and file the petitions, and the court refused to file the petitions, and they had requested me to leave, and I wanted to make sure that this was documented and that all the evidence was preserved and whatnot. Ultimately, officers were called to the municipal court clerk's office Tuesday morning, where a man was reported being unruly with employees. The man, they said, was upset about how the paperwork was filed with the court. Well, they didn't file paperwork. And on the next day, you'll see in the this date was the September 14th or 15th. I'm not sure what the paper was, but anyway, the date here is September 15th. So on 9/15, I had gone to New Philadelphia Police Department and filed a complaint. And you'll see Antonio talked with officer, advised he wanted to file a complaint in reference to he receiving a ticket on Patrolman Road. The original copy seems to appear different from the original documents from case. This is the ALS. Was within the case. Was refusing to leave because he wanted a crime scene established. 3 petitions, time-stamped or written request that they were presented to the court. So you have a First Amendment right to petition the government for redress of grievances. I have carbon copy citations sworn under falsification and perjury that appear changed, and I have a court that had multiple things, rules of procedure that I knew weren't followed. It appears that they knew. Oh yes, the officer had worked for a court. You heard all the issues that were within the suppression that seemed to conflict with the Terry versus Ohio. So here's New York Times versus United States, that every moment continuous restraint amounts to a flagrant, indefensible, and continuing violation of the First Amendment. So where there are issues of violation of the First Amendment and where they willful, let's go further. It is established that denial of First Amendment for minimal periods of time unquestionably constitutes irreparable injury. So are the issues of irreparable injury and so for the injunction, it mentioned irreparable injury. When this occurred, So the officer, there is also issues of, he'll be later indicted on issues of steroids. Supreme Court has held that suppression occurs when the government failed to turn over evidence that is known only to police investigators and not to the prosecutor. An individual prosecutor has a duty to learn of any favorable evidence known to others acting on the government's behalf in the case, including the police. In the entire time of the propensity of multiple cases that I've been in court multiple times, I've gone to the police station multiple times, talked to the attorney several times, is in all these encounters and all these hearings, they never disclosed that the citation that is sworn under falsification and perjury has been changed from the original. When was I even served the particulars of the citation? Is there issues of countless now constitutional issues with this tampering? Here's Ohio Revised Code. Any person known an official proceeding or investigations in process is or is about to be or likely in a situation shall do any of the following: alter, destroy, conceal, or remove any record, document, or anything with the purpose to impair its value. Perjury. Obstructing justice. So here's just some of the issues that were occurring within the OMBI, or the August 6 bike crash and the subsequent arrest for operating a motor vehicle under the influence. So here, there was issues of unjust pursuit, unclear distance, forced off the road causing crash and bodily injury, issues of excessive force, issues of gross negligence, issues of unlawful intrusion, issues of invasion of privacy, issues of illegal search and seizure, issues of lack of probable cause, issues of false or unlawful arrest, issues of unparticular of charge, issue no accompanying charge, issues of lack of Miranda, issues of deprived to be informed of wanting, depriving counsel, issues of summary judgment in custody of an armed officer while I was bleeding, issues of unlawful detention, issues of the local radio and newspaper of misrepresenting particulars of the arrest and facts of the incident, issues of the deprived magistrate, issues of deprived critical proceedings of the initial appearance, issues deprived being informed of particulars of charge, issues of defective charge, issues of constitutionally vague, issues of deprived assistance of counsel at hearing, issues of no determination of probable cause for the arrest, issues of the exclusionary rule of the judge being hedged, issues of involuntary waiver of the speedy trial for the suppression, issues of the involuntary waiver of the speedy without the consent of client's consent. There was issues of a driving under suspension conviction by the very judge that knowing the matters of a suppression. Issues of due process and equal protection are deprived of an impartial judge on the suppression hearing, which they were hedged with the suppression. And now the new issues of the state, issues of withholding evidence, issues that the citation was altered, issues that there was the crash report missing, issues that the ALS is altered. We'll further discover that the booking report from the Sheriff's Department or released that information showed wasn't under the influence. There was issues of being withholding evidence for nearly a year and 3 months, or a year and 2 months. Issues of never informing of that. Issues of not even being informed of the change within the citation. There's issues also of the suppression that the judge changed the particulars. Further, there was a lot of issues failing to provide the initial appearance and how these matters, how all these attorneys and things are going into the court, and this is occurring. So they're just countless issues. There were further the issues of the judge determining the crash without due process, issues of lack of subject matter jurisdiction in determining that, issues of the discovery violation with that proceeding, of issues of the withholding evidence. There was issues of the falsification, issues of perjury with the obstructing justice, if there was fraud in the procurement of those proceedings, the conflicts of interest, due process, and equal protection. There's the issues of the First Amendment being deprived of the to file, and then so there were just countless conflicts of interest and venue issues. On September 17th, this was 2 days after filing the complaint, the law director, Tom Watson, had passed. Here he was good friends with the law director, or Zachary Space, the judge's husband, was good friends with the law director. The counsel or someone appointed the judge's husband to fill the vacancy of the law director, in which the law director serves as general counsel for Dover and tries misdemeanor cases. So there's issues of that conflict of interest and him overseeing the prosecution, in which his wife was making rulings on. Judicial conduct and whatnot, accepting or reporting of gifts, loans, benefit. Here are other things of value. A judge shall not accept or shall urge the judge's spouse not to take, accept any gifts, loans, benefits, or other things of value. So is there issues of the judge's appointment, the law director position, and are there issues of her disqualification? So there was disqualification by the judge. The judge presented three options with the disqualification, and are those remedies for that situation? So here, I don't think the remedies that they provided correct the conflicts of interest that exist in the case while her husband is overseeing the prosecution. So are there constitutional issues with regard to that? And are there issues of separation of powers within this case? I also went to New Philadelphia law director regarding these matters, and I believe these are his handwriting, and I kind of scribbled some of my stuff on here. So he was aware of certain things that were transpiring within this court in the case. 18 U.S. Code, deprivation of rights. Again, the Brady, if the prosecutor failed to disclose the change of the citation and whatnot. So ultimately, I had filed a motion for reconsideration with the district court after this tampering issue, and it was dismissed or overruled, stating issues that it was past the 10 days, which I believe that there's issues of the right of habeas corpus, and also I think it's Younger versus Gilmore, the assistance of the preparation of the writs and the right to be heard in those matters. I ultimately appealed that into the federal court of appeals. However, that matter was dismissed for lack of payment at that point. So those issues were never reviewed or examined at a higher court because of cost issues. So during all these proceedings, the court, the state of Ohio had stayed the case, and I believe it lasted close to 5 to 6 months, 5.5 months. Ultimately, a visiting judge had been appointed finally, and that was Judge Todia. In the pretrial hearing, questions regarding the judge's husband overseeing the prosecution of this case, where it appears to be defective in all these constitutional issues, which I mentioned to the court. And here, I don't see how her husband appointment, the court, oh, well, I I'm not going to I'm not going to get into that either, but whatever, the court, whatever it is, I've been appointed now, for whatever reason, appointed by the Supreme Court, and those things seem to be in order. There are a number of these cases that I've been, doesn't today in that situation, and I'm not going to go behind that. We'll just have to wait and see. So are there countless legal issues of that conflict of interest or the separation of powers of a judge making rulings and her husband overseeing the prosecution? And did any of the attorneys address that? And so are there issues of ineffective assistance of counsel for failing to raise that or refusal to raise those issues, particularly in this case as well as on the appeal and to higher courts? Is there any irreparable injury of separation of powers that would have triggered countless constitutional issues in this matter? I think it's within these proceedings. So are there issues that the charge was defective here? Rules represented by counsel, if there's some defect in the citation and all that, I think he can represent that on your behalf, but the prosecutor's not prepared. I would say it have to be done in writing. The prosecutor's not prepared to respond to oral motion at this time. Are we addressing the ALS in this matter? Excuse me. So there was numerous issues of why counsel never presented the issues of the particulars and all the defect and all these things that were transpiring. And are there issues that there were conflicts of interest with counsel? And are there issues that the appointment of counsel was from the judge where there was issues? So is a judge appointing people that may not question some of the things of her ruling? So are there conflicts of interest with that? Let's go a little further. Also in that pretrial hearing, there was discussion of the ALS. Almost 2 years without here. I think in the fact that the period has expired. It's almost 2 years without a license here. I'm going to vacate the ALS. So there was issues that he's stating that there was going to be vacating it, and if there was ever entries into the issues of vacating it, which raises a lot of issues of Heck versus Humphreys and all those legal issues of the driving under suspension and all the issues tied with that. We'll also discover that the ALS will infuse with the OMVI after a conviction, which I do not learn this information until after a conviction. So there are issues if there was tampering, if there was falsification and perjury within the ALS, that you have multiple and where that came out of. So then you have multiple jurisdictions and legal issues of proceeding with a conviction or attempting to obtain a conviction of, and if it would be a valid conviction. So that raises a lot of legal issues of Younger versus Harrison of not obtaining a valid conviction and seeking relief into federal courts. There was also issue of venue, not only all the things that were going on, the conflicts of interest, the public notoriety of all these issues, and the false information that was published by individuals. The counsel had placed motion regarding the speedy trial issues. However, he never raised the issues of the rules of criminal procedure not followed, and if counsel is given the full 35 days to file the motions, creating the legal issue and choosing between rights or requiring the file leave to file the suppression. Further, we know that there was issues that never giving consent to counsel to waive those. And it's not only did I not give consent, it was specific that he was not to do that, as well as we were in court proceedings, which the court as well as the prosecutor knew those issues. So it appears that he affirmatively disregarded a directive of me, of what I requested, as well as that it appears that I affirmatively asserted with the court of what I wanted. So does a court, can it continue to pressure to seek waiver? Would those issues should have stopped immediately once I assert the right to the speedy trial issue? So this motion, I believe, there are a lot of issues of failing to disclose information in that. Within this motion as well, you'll find that it may be 3 months or more before a trial begins. So there are further delaying issues. I went into federal court again in this particular time. So I went into federal court again. This time I petitioned pursuant to the First Amendment to the U.S. Constitution. For those that aren't too familiar, is that the first civil rights actions appear to be derived through a congressional act. The First Amendment prohibits Congress from making any laws or infringing upon certain rights. And the habeas corpus proceedings is within the original Constitution. So the First Amendment amended the Constitution. So it appears that the First Amendment provides an instrument of petitioning the government for redressing grievances. And I was going to exercise that instrument in that. I did further discover, while this was going on, that within the Union case in which the Northern District Court had been involved in, it appears that there is a clear issue that the court had known that there were legal issues within it, and it appears that they intentionally, so there were issues of due process and equal application of law, as well as issues of cruel and unusual punishment within that case. And you'll see that I'm an interested party in that action. You'll further want to examine if the declarations in that case are true and accurate, and then if the order is even possible. So we're discovering a lot of issues within the Union case, and I felt that there was considerable issues that it was not a fair and impartial venue. I felt that the court was not fair and impartial. In that proceeding, the court, federal judge, Polster, ends up placing an order permanently adjourning me from filing documents with the court, and certified appeal could not be made in good faith. Further, the clerk was instructed not to accept or file any further documents in the action, thus I couldn't file a notice of appeal. Additionally, I faced threat of contempt and may be punished accordingly if the order was violated. So I was never given an opportunity to be heard, never heard before the order was entered. There's issues that never warned or cautioned, never explained what particulars meant in the case, and never gave an opportunity to present evidence in any of those matters, nor the ability to amend the complaint. So there was massive legal issues of this proceeding, as well as of what was going on in the state case. In Trump v. Dulles, there may be involved no physical mistreatment, no primitive torture. There is instead a total destruction of an individual's status in organized society as a form of punishment more primitive than torture, for it destroys for an individual the political existence which was in centuries in development. The punishment since the citizen of his status in the nation and in international political community. This punishment is offensive to the cardinal principles in which the Constitution stands. It subjects to an individual a fate of even more increasing fear and distress. He knows not what discriminations may be established against him. So are there legal issues that I had legal issues within the Union case that was transpiring? I had multiple legal issues with the state case of multiple things. There's a whole set of legal issues within this order. I don't want to get too far. So I still want to... And here I had several cases. Here, the case that the federal judge cites, the guy had 176 cases filed, and conservatively they're saying 300 lawsuits. I had a couple, and I believe mine had absolutely valid grounds. Here, there can be no sanction or penalty imposed upon because of exercise of a constitutional right. So I'm being sanctioned for exercising a federally protected right, trying to protect my rights within the state case. There can be no involvement. This is again Trump versus Dulles. He knows not what discrimination may be established against it. So in Trump versus Dulles, they're saying may be established, where there are multiple legal issues that were being directed against me. So in Trump versus Dulles, am I in a worse position than this case? So if it's more primitive in torture, is my case worse than his? And there's just countless case law regarding the First Amendment. Here, the exercise of the constitutional right for an individual is dependent on the mechanism to uphold those rights and protect them from violation or denial. Consequently, access to the court, a pivotal right which the vindication of persons' other constitutional protections pretend. This court has continuous habeas corpus civil rights action are fundamental importance to our constitutional scheme because they directly protect our most valued rights. Meaningful access to court is touchstone. Now, for the first time in 182 years since the founders of the Republic, federal courts are asked to hold the First Amendment does not mean what it says. In other words, we ask to hold that despite the First Amendment's epiphatic command that the executive branch, Congress, and judiciary make no law adjourning, instead it makes the bold and dangerous, far-reaching contention that the courts should take it upon themselves to make a law abridging freedom. And again here, every moment continuous strength amounts to flagrant, indefensible, and continuing violation of the First Amendment. It is established now First Amendment for minimum periods of time unquestionably constitutes an irreparable injury. A prior restraint, by contrast and by definition, has immediate irreversible sanction if it could be said that the threat of criminal or civil sanctions after publication chills prior restraint freezes. Cromer, notice of a possible Cromer had ensured that Cromer had an opportunity to oppose the court's order before it was instituted. Pre-file is determining whether the pre-file is warranted must weigh all relevant circumstances. Magistrate did not enumerate or discuss all these factors. Just must ensure that the injunction is narrowly tailored to fit the specific circumstance at issue. So did I have countless legal issues? So was it warranted was there First Amendment violations within the state case? So were there just mounting legal issues transpiring now? And here, deprivation of rights under the color of law. It's the right to receive notice before the government deprives an individual or protect interest is guaranteed. After 3 unsuccessful attempts by habeas corpus to ensure release, here the petition is a 4th proceeding. So in Price versus Johnston, there's 4 proceedings. I had a total of 4 things in the federal court, and I believe my cases were far greater legal issues of multiple issues. So anyway, again, there were just countless legal issues in the state case, and oh, this is interesting. This is recently, the House Judiciary Committee is in charge of safeguarding the rights of forward Americans in the U.S. Constitution. These rights include having the freedom and will of one's own affairs. Here, the situation just unjust deprivation of rights by the government. We have an obligation to conduct oversight and explore possible remedies. What's interesting is I had petitioned. So after I got barred access, there was still the state case that was going on, and counsel was not apparently going to subpoena the officer at the county jail, where there would have been the issues of and all the things of what transpired, as well as here the judge stated that he could present that on my behalf. He wasn't doing that. There was no bill of particulars, so the defect, there was just countless issues, and there was issues of what counsel was actually representing too. So was he representing issues of the ALS? Was he representing issues of the crash? Just this countless issues. And by this time, it was nearly 2 years, and it was clear the state. So there were issues that I was deprived access to the federal courts. So I sued in state court, which contained co-concurrent jurisdiction. And so in that one, I filed civil rights actions and whatnot. And here, what's interesting is the illegal charge with OMVI. So in all the other newspaper articles, they never examined the documents. They always interviewed individuals, which they never verified what information they were presenting to the public. So here, where they appeared to have taken it from the complaint, they put the proper of what the arrest was for. When I had filed that, they had fast-tracked the state case, and there are just countless things. I was forced to use counsel that I believe there was issues of conflicts of interest and countless things. And there were just numerous questions that could have been asked, but the office counsel did not want to challenge the integrity of the officer. So there were just numerous things that just tethered to someone in which the judge had appointed. So anyway, I end up getting found guilty in the case. There's just so many things. Let me back up just a little bit. When I filed in the state case, a couple days after the filing, I received a phone call that was left on my answer machine. It went something like, "I'm not going to leave you a message. I'll tell you what, it sounds like Zachary framed me up on the hill, I see, huh? Wait till I get out of here. Oh man." It seemed to be in all follow order. And if you knew what transpired within the state or the incident on August 6th, you'll know that the arresting officer wrote in. There was also Robert Everett that was conducting the field sobriety moments after the crash, and he had ordered the arrest. So it seems to be that this message was left by the arresting officer. And after this occurred, there had been the fast tracking of the case in the state case. And as I mentioned, the counsel didn't want to question the integrity. And you'll see that there's just countless inaudible things. So to get into all the things that transpired at trial, I mean, there was just so many conflicts of interest and whatnot. So one of the interesting was the court here. Official does not comply with the law, meaning the judge could lose his dub. But what I'm saying, so there was just so many things. And they never questioned, like, there's just some, never determined who altered the ALS. While we're in trial, the prosecutor was presenting the ALS. She hands it to my attorney, and I try to examine it because I'm trying to figure out. I knew like certain ones which were empty and whatever, and there was the copy within the driving under suspension that was filled in. So I'm trying to determine which ones were of the carbon copies were tampered with. And I'm trying to read it, and they literally refuse me to even examine this document. So, actually, during recess, while everyone was leaving the courtroom, I was making notes and waited till everyone left. And it was sitting on the prosecutor's desk, and I went over and just leaned over to examine it. And I saw that it had been filled in, I believe. And I think that was the one from the Ohio Bureau of Motor Vehicles. And that's when I think I realized, like, that it appeared to be a state agency tampering with it. So then there was issues of multiple jurisdictions and multiple issues and issues of the conspiracy to deprive rights. Like, all these things were going through my head. And at recess, I had asked my counsel, had you ever mentioned, or has law enforcement ever discussed this case with you? And he had mentioned that the arresting officer came to his office, and they had a meeting or something of that nature. I'm not even regarding discovery. So I'm like, all this time, he never discloses to me that what the officer had mentioned to him, or who, or how, what was explained. So I was really disturbed at that incident. And there's just multiple things. And here, like, he never challenged when I asked for immediately asked for an attorney. So at the BAC, are there issues that an armed officer who's making judgment while you're bleeding, and also that you had asked for counsel, and did what is supposed to occur once you request counsel? There was request for the trial transcripts, and after some delay as well, there was appointment of attorney Michael Putaball. Now, what becomes interesting is it appears that he's friends with the law director, Zach Space, and I believe he went to school with him and whatnot. We can also see Tanner's website. I actually contacted the Tuscarawas County Bar, and there was a referral. I actually had an appointment with counsel from there, and you'll see on his website here. So anyway, I just happened to be going to his for a certain, and while I'm going through here, so that's interesting, and you'll see, I think I mentioned how the air. It says plaintiff's motion to suppress evidence here. The officer lacked his warrant to stop probable cause for driving under the influence. So in the appellate's motion, if you examine what the appellate motion is here, motion to suppress filed by Gary Gray, you'll see we used OMVI. So here on appeal seems not to be what the actual suppression was. There's issue also that I think here, stay imposed sentencing. I think on an appeal or a filing mentioned that there wasn't a stay. Here, the right to counsel on appeal encompasses the right to effective assistant counsel, not mere nominal representation. So while this was going on, also I'll mention here the officer Roden, here Mike Roden, member, was secretly indicted by Touch grand jury of 3 counts of drug possession. Here you'll see who his counsel is. Roden's attorney, Mike Putaball. So isn't that interesting? During the appeal, the trial transcripts were not being released on the and here's the issue. There's things about the internal memo of withholding the initial appearance. Here's Here I had a member, September with Tanner. Anyway, so I was looking through the website, I discovered that. So while I was on the appeal, I filed the Freedom of Information, or excuse me, the Sunshine Request Act in state court. And that's when we discovered so here the Sunshine Request document regarding the affidavit by the sheriff, the captain. Dover Police Department did not prepare Ohio crash report in connection with the incident leading up to the issuance of said citation. There is not now, nor there has ever been, a crash report pertaining to the incident leading to the aforementioned citation. Crash report 99352 is a true copy of the original filed. So for those that aren't, so here's the crash report, and this is sworn under the issuing law enforcement states under the penalty of perjury or falsification the above complaint is true. So how in the hell is this captain swearing under oath or putting an affidavit before the court? Does he have direct knowledge of facts, and how does he assert some of these in these affidavit? And further, so let's just go over the citation at this point. So ultimately, during the release of the Sunshine Request, they finally disclose the ALS, or excuse me, after filing the Sunshine Request Act, we finally get the BAC data master, and you see the times, and you see some of the issues. You'll see, and this is actually the officer or someone from there noting this or putting this writing on. So here it's at 4:56. The citation has 4:46. So there was a 10 minutes difference. And so from 4:56 to 4:57 on the bike, with the bike. And as I discussed in the first part, so this appears to be within 1 minute, issues of the concussion, the crash, and whatnot. So only after legal of a different court of compelling them to produce the evidence did the city of Dover release this information. So are there serious issues? And unfortunately, the appeal had been filed. So is there any equal protection due process of that? And we'll get into a lot of the if they have corrective processes, if the state has jurisdiction on those. So it was brought to the highest court of right on appeal, and so they were withholding evidence all through that. So are there just countless legal issues, and then the issues of being blocked access to the federal courts to seek remedy in these situations. So we can go through. So the conflicts of interest, the ones in the red is when the initial federal action, and then the ones in blue are on the motion for the reconsideration. You'll see just how many legal issues there are in this case. We can get into all these are the more particulars of the August 6th bike crash and the arrest for OMVI that was about a minute. So I'd like to thank you for your time. Goodbye.